Daktari. Yes, please.
Yes, I appear with my able and friend from Mali.
I'm present, Your Honor.
My land friend Ms. Wanjohi.
I'm present, John.
My land friend Ms. Mwenda.
I'm present, John.
My land friend Ms. Shatra Kwomboy. He must be somewhere around. Yeah, he always comes to court. And my land friend Ms. Mwenda.
I am present, John.
And my land friend Ms. Nekesa.
I'm present, Your Honor.
Your Honor, our client is in court, Brian Mwenda. And we intend to be very brief this afternoon.
Thank you.
Yeah, we do not intend to take much of your time at all. In fact, I've got 5 minutes in my mind.
Okay, thank you.
Your Honor, for the state, my name is Rugut. Appearing alongside Mr. Joe.
Your Honor, present.
Mr. Joe with me.
Good afternoon, Your Honor.
Good afternoon.
Mr. Murithi
Present, Your Honor.
and Mr. Bore.
Present, Your Honor.
Your Honor, good afternoon.
Good afternoon.
Your Honor, I appear for the Law Society together with Ms. Faith Odhiambo. My learned senior, Mr. Omaza Umbati.
Present, Your Honor.
Mr. Stephen Wanjiru.
Present, Your Honor.
Ms. Nicholas Ovinya.
Present, Your Honor.
Mr. Mora Kabata.
Present, Your Honor.
Mr. Noel Odiwol.
Present, Your Honor.
Mr. Mugendi Jared.
Present, Your Honor.
Tali Israel Tali.
Present, Your Honor.
Mr. Otieno Robert.
Present, Your Honor.
Mr. Robert Sharma.
Present, Your Honor.
And Mr. Mwenda Munene.
Present, Your Honor.
Ms. Effie Sheila.
Present, Your Honor.
Thank you, Your Honor.
You're welcome. So the whole room is full of advocates, apart from the journalists. This is the ruling. You mute everyone online. You've done it? Yes. Okay. The accused person herein, namely Brian Mwenda Njagi, faces a total of 6 counts He pleaded not guilty to each of the 6 counts. Plea was taken yesterday at 3 p.m. at the request of learned counsel for the accused person, namely Dr. Aminu, who requested that plea be taken at that time, and he had another matter before Thika Law Courts, and there was slight delay in registration of the charge sheet from the prosecution side. Immediately after plea taking, the defense counsel for the accused person raised a number of objections, which they preferred to submit on ahead of submissions on bail bond pending trial. This ruling, therefore, relates to objections raised by the defense counsel on record. Mr. Bryan, you may have a seat.
Thank you.
Thank you, Honor.
The first objection was with regard to participation of the Law Society of Kenya in this case as a victim. Mr. Omari, advocate for the accused person, submitted that the chairman of the Law Society of Kenya and members of the Council of the Law Society of Kenya cannot participate in this case because they are potential witnesses for the reason that they made complaint with the police and recorded statements, that they can only appoint an advocate to represent the Law Society of Kenya as a victim, that the premises of the Law Society of Kenya, that is the headquarters, is a scene of crime, and that if investigations implicate staff or council members, then they might end up being accused persons, and for that reason he submitted council members cannot appear in their official position. Relying on Rule 9 of the Advocates' Practice Rules, Ms. Mwai, also defense counsel, submitted that the same provides that no advocate may appear as such before any court or tribunal in any matter in which he has reason to believe that he may be required as a witness to give evidence. She submitted that in count number 6, the accused person has been charged with access to Law Society of Kenya online account, and that this may require Law Society of Kenya to testify before this court. Counsel relied on authorities in the matter of Justice Sankale versus Inspector General of Police and another High Court petition number 334 of 2021 unreported, and Republic versus Silas Mutuma and 2 others, 2016 EKLR. She submitted that in those 2 cases, the advocates concerned were barred from participating in the trial as representing accused persons because they were potential witnesses. She further submitted that it is in the public domain that the Law Society of Kenya, through their chairman, lodged a complaint in this matter, and all members received a statement of the President of the Law Society of Kenya dated 13th of October 2023 that there was a resolution to report the issue of the accused person to the Directorate of Criminal Investigations. She submitted that the statement was signed by the President of the Law Society of Kenya, and therefore the President and Council members of the Law Society of Kenya are potential witnesses and therefore should not act as advocates. Mr. Wamboi, on his part, submitted that Section 2 of the Victim Protection Act defines a victim as a natural person who suffers injury, loss, or damage. He submitted that the court needs to make a determination whether the Law Society of Kenya is a natural person. He further submitted that some of the counsel representing the alleged victim, including the president of the society, are likely to be called as witnesses either for the state or the prosecution, and that counsel for the Directorate of Criminal Prosecutions, namely Mr. J.V. Owiti, will potentially be called as a witness as an individual who witnessed the skill and zeal of the accused person, and that he vehemently objects to participation of the said counsel alongside participation of the President Vice President and council members of the Law Society of Kenya. On his part, Dr. Hamino, advocate for the accused person, also submitted that there is a new concept in common law known as equality of arms, which means that an accused person being prosecuted should feel that there is equality in representation and that he will not suffer any prejudice. He further submitted that if the court admits the Law Society of Kenya, the accused will suffer great prejudice and will not be accorded fair hearing because the DPP will now be supported by the LSK. And finally, that LSK cannot be a victim at all, that there is reference to victim in the Constitution, and that the victim is a natural person, and therefore the LSK cannot be a victim at all. The prosecution counsel, Mr. Owiti, submitted that there is no fact, no affidavit to prove that he would be a witness, that a private citizen does not have the right to compel a witness to be his witness, and that anything that he does in his capacity as a prosecution counsel is protected by Section 15 of the Office of the Director of Public Prosecutions Act, and that as long as he does his work in good faith, he is immune from civil or criminal claims. He further submitted that the said provision protects him from being a potential witness and that there is no basis for barring him from the case, and that the choice of witness is within the mandate of the Office of the Director of Public Prosecutions, whom they will ably represent. Mr. Njue, on his part, submitted further to the submissions made by Mr. Owiti Let me read that again. Mr. Njue, on his part, submitted that further to the submissions made by Mr. Owiti, the submission by Mr. Wamboi that Mr. Owiti is likely to be called as a witness to testify of the expertise of the accused person is not well founded because none of the charges facing the accused person talks of expertise. He further submitted that there is no Law Society of Kenya without its membership, that no conflict of interest has been alluded to, that Brian Mwenda is an offended person and reserves the right to choose his advocate. And that by extension, his membership as a natural person touches on the Law Society of Kenya as a corporate body. He submitted that none of the advocates' recorded statements and that none of them is likely to be called as a witness for the prosecution. On his part, Mr. Theuri, advocate, submitted that the complainant in this matter is a statutory body known as Law Society of Kenya, that the Law Society of Kenya is a statutorily incorporated body by virtue of provisions of the Law Society of Kenya Act and has absolute right to determine who will represent it in any proceedings before the court, that it does not fall on the accused person or any other person to determine the advocate that the Law Society of Kenya, that is LSK, will appoint, that Section 26 of the Law Society of Kenya Act establishes the secretariat that has been put in charge of running the day-to-day affairs of the secretariat, and therefore administrative running of the society is a function that is exclusively of the secretariat, that the Law Society of Kenya Council, established under Section 17 of the Act, only gives general policy guidelines. He finally submitted that the two authorities cited by the Defense Counsel relate to the question of conflict of interest, that is, that an advocate has handled a case for a client that raises a situation of conflict of interest in terms of information he may have obtained from that client, or that he has obtained information from a client that is relevant to the issue before the court and therefore rendering the advocate a potential witness. He further submitted that if they go by the qualification that has been given by the defense counsel, then any advocate is a potential witness, including the defense counsel, because the test given by the defense counsel is of a roaming target that can land on any counsel. Mr. Theory further submitted that Article 50 of the Constitution has elaborate mechanisms to ensure the concept of equality of arms, which he submitted is not merely the number of advocates, but how the court balances the Article 50, sub-Article 9 rights on participation of victims in this case. That Article 50, sub-Article 9 of the Constitution expanded participation of victims in a trial with a view to achieving the concept of equality of arms, that the defense has failed to demonstrate what kind of prejudice the accused will suffer if the Law Society of Kenya participates in these proceedings. Further, that the court cannot exclude participation of victims because that will end in the victims suffering prejudice, that the proceedings before the court have a significant bearing in the rule of law and administration of justice in this country and touch the very heart of the concept of justice, access to justice, and that what the Law Society of Kenya has complained about, if left unchecked, then the provision of justice will be severely compromised. He further submitted that the mandate of the LSK at Section 4 of the Law Society of Kenya Act is to protect the conditions of practice of law in this country, and that it is important that the statutory body charged with the responsibility of ensuring practice of law is not watered down and held in high ethical standards to have a say in these proceedings. Mr. Theory referred to the case of Republic versus David Mushiri Mwangi, 2018 EKLR, where he submitted the question of participation by victim during bond stage was made, and court relied on the case of Joseph Waswa versus Republic, 2020 EKLR, and the case of Republic versus Frederick Oleleiman, where the court found that the Law Society of Kenya was a victim and was allowed to participate in those proceedings. He therefore asked the court not to depart from the authorities of the High Court he cited. Mr. Omwansa, also for the Law Society of Kenya, reiterated the submissions made by Mr. Theory and further submitted that the Law Society of Kenya does not issue practicing certificates, that Article 260 of the Constitution defines a person to include a corporate entity. He further submitted that a preliminary objection must be based on pleadings and referred to the case of Nairobi City Council versus Thabiti, 1996 EKLR, where he submitted the Court of Appeal said that a preliminary objection must arise from pleading and cannot arise from the floor. He urged the court to dismiss the objection and allow the LSK to participate in the proceedings. Further, that the President of the Law Society of Kenya introduced several advocates and no evidence of conflict of interest has been presented before the court to demonstrate any conflict of interest, that there is no evidence that the prosecution recorded any statement from any of the advocates, nor indication that they will call any of those witnesses. He urged the court to allow the LSK to participate as per Section 4 of the Law Society of Kenya Act. Ms. Nicholas, on her part, while referring to the provisions of Article 50, sub-Articles 7 and 9 of the Constitution, submitted that one, Brian Mwenda Ntwiga, is a natural person, and that it is strict law that victims' right to participation in the process subsists throughout the trial, including during plea taking, actively and not passively, that the right to fair trial is enjoyed by victims and not just accused persons. She submitted that the counsel are here watching brief for one Brian Mwenda Ntwiga. I hope that is the right pronunciation. That's a summary of the submissions made by counsel for the accused person, for the prosecution, and for the counsel who have come on record for the alleged victim of the alleged offenses. Due to constraint of time, I could not have reproduced all the submissions in this ruling, hence the summary. I have considered all the submissions made by each and every counsel who made his or her submissions. The first issue for determination is whether what the defense counsel have raised fall within the non-description of preliminary objection. A preliminary objection must be on a point of law. It cannot be premised on any fact or allegation requiring proof. The Court of Appeal in the case of Mukisa Biscuits Manufacturers Company Limited versus West End Distributors Limited reported in 1969 volume of East Africa Law Reports at page 696. At page 700, paragraphs D to F, Law JA, as he then was, had this to say, and I quote, "A preliminary objection consists of a point of law which has been pleaded, or which arises by clear implication out of pleadings, and which, if argued as a preliminary point, may dispose of the suit." Examples are an objection to the jurisdiction of the court, or a plea of limitation, or a submission that the parties are bound by a contract giving rise to the suit to refer the dispute to arbitration. End of quotes. At page 701, paragraphs B to C, Sir Charles Newbold, President of the court, added the following, I quote, "A preliminary objection is in the nature of what used to be a demurrer. It raises a pure point of law, which is usually on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the exercise of judicial discretion." End of quotes. Issues relating to whether a person or entity can participate in the proceedings as a victim, and whether any particular advocate or team of advocates can or ought to participate in the proceedings, are not issues which, when determined, can finally dispose of this criminal trial. What the defense counsel referred to as a preliminary objection, therefore, does not meet the requisite elements of a preliminary objection. It is important to note that as a good practice, it is proper that before any party raises and argues a preliminary objection, there should first be filed and served a notice of preliminary objection stating the grounds upon which the same is to be raised, so that there is sufficient notice to the opposite party. The next issue for determination is whether the Law Society of Kenya is a victim in this matter, and whether the Law Society of Kenya should be allowed to participate as such or denied a chance to participate in the proceedings. Definition of a victim is found both at Section 2 of the Victim Protection Act and Section 329 A of the Criminal Procedure Code. The latter mentioned provision was explained in the case of Leonard Maina Mangi versus Director of Public Prosecutions and two others, 2017 EKLR as follows, and I quote, "Later amendments to the CPC through Act number 5 of 2003 introduced victims in the criminal trial process. The code was more elaborate in providing for an expanded definition of a victim, as well as the place of victim impact statements in the trial process, most notably to inform the court before granting bail and also before passing of sentence. This progression makes its way in the law before the promulgation of the Constitution. End of quotes. Section 2 of the Victim Protection Act defines victim as follows, I quote, "Victim means any natural person who suffers injury, loss, or damage as a consequence of an offense," end of quotes. Section 329 A of the Criminal Procedure Code defines a victim as follows, I quote, "A victim means a primary victim or a family victim." Primary victim is defined as follows, I quote, "A primary victim in relation to an offense means A, a person against whom the offense was committed, B, a person who was a witness to the act of actual or threatened violence, the death or infliction of the physical bodily harm concerned, being a person who has Law Society of Kenya, and one Brian Mwenda N. Sorry, there's a spelling error there. Let me correct it. A plain reading and holistic application of these provisions leaves no doubt that the Law Society of Kenya and one Brian Mwenda N, who are mentioned in the particulars of offense to counts numbers 6 and 1 respectively, are entity and person respectively, against whom the alleged offenses in the said particulars are alleged to have been committed. Each of those two is therefore a primary victim within the definition of victim at section 329A of the Criminal Procedure Code reproduced herein above. But still, even going by the definition at section 2 of the Victim Protection Act, there is no doubt that the Law Society of Kenya is an association of natural persons, part of whose membership includes each and every advocate appearing in this case, each of whom acknowledged that fact. From the definition at section 329A of the Criminal Procedure Code, the fact that one is a witness or a prospective witness does not preclude the person or the entity from being a victim. I find the decision of, no wonder it refused to print, there are so many spelling errors. Let me correct it before I continue. Yes. I find the decision of the Honorable Lady Justice Kasango J in the case of Kraft Silicon Limited versus Republic, Criminal Revision number E30 of 2021, reported in 2022 KEHC 424, quite relevant to the circumstances of this case. In that case, the Honorable Judge said as follows, it's a long quotation, I'll read the whole of it. Flowing from that discussion, it ought to be noted that it is a legal principle that a corporation is treated as a distinct legal entity from its shareholders. When that corporation, however, suffers economic loss as a consequence, for example, of cybercrime, as it happened in the case at hand, the real victim of such an offense is the shareholder. The harm is done to the shareholder personally as a result of loss to the company's share value. It follows that, corollary to the example I used above for a murder case of who the victim is, when a corporation suffers as a result of a crime where there is loss which affect the profitability of a corporation, it is the shareholder who is a victim. And although a shareholder can either be a person or a corporation, even where it is a corporation is a shareholder of that other corporation, there is always a natural person who is a shareholder somewhere down the line, and it is that one who suffers the consequences of a crime committed against the corporation. Further, it is important to note that Article 50, Sub-Article 9 of the Constitution mandates Parliament to enact legislation to provide for protection of rights and welfare of victims of offences. That article of the Constitution does not discriminate on who can be considered to be a victim. Section 9, subsection 1 of the Victim Protection Act recognizes the involvement of a victim in a trial. In particular, subsection A of that section states that, quote, a victim has a right to be present in their trial either in person or through a representative of their choice. That right was recognized by the Supreme Court in petition number 23 of 2019, Joseph Lendrix Waswa versus Republic, where it stated that, quote, although the adversarial criminal trial process is a contest between the state represented by the DPP and the accused, usually represented by defense counsel, and the traditional role of victims in a trial is often perceived to be that of a witness of prosecution, it is without doubt that flowing from both the Constitution and the Victim Protection Act, and in particular Section 9, subsection 2A of the Victim Protection Act, that a victim too has the right to participate in criminal proceedings. And she continued at paragraph 29. The Constitution under Article 27, frowns on discrimination. In particular, I will reproduce Article 27, Sub-Article 1 as follows. Every person is equal before the law and has the right to equal protection and equal benefit of the law. With the above provision in mind, it is not correct to treat shareholders who suffer from consequences of economic crime and who are not excluded under Article 50, Sub-Article 9 of the Constitution differently from other persons, such as a family member of a person who has been murdered. It is in view of the above discussion that I dissent with the holdings in the case of Kimuri Housing Company Limited and another versus the DPP, and Kenneth Njiru Njagi versus Republic, Lineal Company Limited and another. I find and hold that the legislature, in terming victim as a natural person, could not have intended to discriminate against shareholders of a corporation just because they are in the shadow of that corporation. End of quotes. That authority is clear that a victim cannot just be a natural person alone. This authority is binding on this court. I therefore find and hold that the objection raised on the basis that the Law Society of Kenya is not a victim for not being a natural person fails for lack of merit on the basis of the foregoing reasons. The next issue for determination is whether the President, the Vice President, and Council members of the Law Society of Kenya should participate in these proceedings, and whether the Law Society of Kenya should be asked to appoint an advocate to represent it, and not the President, the Vice President, or Council members thereof. It is the parties sorry, officer, fungua mlango tupate hewa. Thank you. It is the parties to proceedings before the court who appoint advocates to represent them. Once an advocate appears before the court and as an officer of the court introduces himself or herself as representing a party to the proceedings before it, the court cannot go beyond that and seek to establish whether a person appearing as an advocate before it has been properly appointed by the person or entity he or she represents. Equally, every person or entity before the court has the right to be represented by advocate of own choice, and therefore any party seeking disqualification of any advocate representing any party before the court must file a formal application accompanied by a supporting affidavit detailing the reasons as to why such an advocate should not appear for a particular party. Such an application must be supported by evidence because the consequences, if successful, are major. Such evidence must clearly indicate a conflict which might arise as such advocate performs his or her dual responsibilities as an officer of the court and as a legal representative of the party before the court. In this case, no evidence of such conflict has been adduced before the court with regard to the advocates appearing on behalf of the Law Society of Kenya, nor with regard to the advocates appearing for the Director of Public Prosecutions. Fair trial includes the right to legal representation of any person appearing before the court as a party. I rely on the publication by the United Nations Office on Drugs and Crime, otherwise known as UNODC, titled Kenya Training Manual on Human Rights and Criminal Justice Responses to Terrorism, where it is said at page 76 as follows, I quote, "The African Commission on Human and People's Rights, Principles and Guidelines on the Right to a Fair Trial and Legal Assistance in Africa provides as follows, quote, A, states shall ensure that efficient procedures and mechanisms for effective and equal access to lawyers are provided for all persons within their territory and subject to their jurisdiction without distinction of any kind, such as discrimination based on race, color, ethnic origin, sex, gender, language, religion, political or other opinion, national or social origin, property, disability, birth, economic or other status," unquote. And it continues to say, I quote, "Similarly, the United Nations Basic Principles on the Role of Lawyers states, quote, all persons are entitled to call upon the assistance of a lawyer of their choice to protect and establish their rights and to defend them at all stages of criminal proceedings," end of quote. The right to choose and the right to be represented by an advocate of own choice are key components of the principle of equality of arms. It is my view that by making a decision disqualifying an advocate from appearing in the matter without proper justification or basis would be tantamount to denying the party the right to be represented by advocate of own choice. There cannot be fair trial as contemplated under Article 50 of the Constitution without equality of arms. Based on the foregoing reasons, I find that the objection raised by the Defense Counsel are not well-founded nor supported in law, hence none of the objections raised is merited. The objections raised are therefore each rejected and each of the prayers sought is declined. I am, however, grateful to each and every counsel for input and contribution to continuous learning of the law. That is the end.
Most obliged.
Your Honor, probably we go first.
Just a moment. It's about to go off. Let me switch it off. And Mr. Witty, I have a request.
Yes, Your Honor.
To you and to everyone.
Yes.
A humble request, not a directive, that you try to be as brief as you can.
Yes.
So that we finish early.
Okay.
We have a long holiday ahead of us, so I would want to hear everybody, and if possible, I do my ruling here, so that as you go home, you know what I've decided. You don't want to spend a long weekend with this ruling hanging on my head. So how long will you want to take?
Around a minute. Your Honor, from our end, hoping that I'll persuade you that we have the last word. I'll go for 10 to 15 minutes. My colleague, Planet Senior, Mr. Good, will do 15, and Mr. Anjue will do 10. That comes to around 40.
May I say something?
Sorry,
May I say
Captain.
something? Your Honor.
Let me finish with him first. Are you able to condense it to a total of 15? Because I see you have an affidavit, you don't need to repeat what is there.
This is
Your Honor, I'm advised we can condense it to 25.
Okay. And
Can you
that-
condense it to?
25, Senior.
Your Honor, I intend to be as brief as possible, so that to give you an opportunity to give us the ruling today, so that I can go out with my client. I'll be extremely brief. I do not wish my client to sleep in prison again.
So you know the outcome.
I'll be very brief.
So I should disqualify myself.
Yeah, in support of my senior, only a simple question. We have not been supplied with the affidavit of the state. What we have is an affidavit filed by Law Society of Kenya, which you summarily dismiss that is not an affidavit for the purpose of opposing bail. And if that is upheld, then the state cannot argue from the bar. Proceed and give the terms. We don't intend to argue because there is no objection to bail. That's what my senior will say. There's no objection to bail, and we are not arguing on anything. We leave the court to make the terms.
I hope we still have the right to go first. We will explain even the fears by my learned colleague, Mr. Omari, as to whether or not the state should or has an affidavit.
Please proceed.
I thought I would make a form of it.
Yeah,
Is that not the way things are done?
there's no supply.
Oh. You want to start first?
Yes, that's
Yes.
the question.
Okay.
The state has not given any evidence.
Your Honor, I intend to be as short as possible.
Okay. Who bears the burden
The state is not
of proving a compelling reason? Whoever has the burden goes first, isn't it? So we need to agree who has the burden, the defense or the prosecution?
This is director.
Yes, so I think the prosecution should go first. Yes, please. So we let the prosecution
The
start.
prosecutor go first.
Yes.
Thank you, please. But Your Honor, the estimate is very brief. as short as, in the old days, we used to say as short as a woman's skirt.
Okay.
I'll probably try to make it as short as a schoolboy's short. But Your Honor, thank you for your directions. It's indeed our belief that because where there is no compelling reason, the court would almost automatically grant bail, that we go first to indicate the existence of compelling reasons. I will, however, address you on just two main issues. Number one is the absence of an affidavit on behalf of the Office of the Director of Public Prosecutions representing the state today. And I will also address you on the issue of the public interest. All these arguments are ring-fenced by the provisions of Article 49(1)(h) of the Constitution.
Just a moment.
Sorry.
So you should be able to finish at 2:45.
Very well, Your Honor.
All of you on your side, yes.
Yes, so we're saying we are basing our arguments on Article 49(1)(h) of the Constitution of Kenya 2010, the provisions of Section 123A, that is 123A, capital A, of the Criminal Procedure Code, Cap 75. We're also relying on the judiciary bail and bond policy guidelines. And I will rely on the decision of the High Court of Kenya at Mombasa, your learned brother M.K. Mohammed, as he then was, is currently sitting before the highest court of the land. In John Kahindi Karisa, John Kahindi Karisa, and two others. The decision is reported in 2010. And I'll start with that and add the court to just turn 24, the decision. The good Lord Justice, Honorable M.K. Mohammed, as he then was a judge, was persuaded that the state must not have an affidavit in its attempts to prove the existence of a compelling reason for the denial of bail. That is my paraphrasing of that paragraph. I am confident that the Honorable Court will have an opportunity to have a look at it. And then that answers Mr. Omari's fears that without having seen an affidavit from the state, then there is no opposition. I have had the benefit of looking at the affidavit sworn by the Law Society of Kenya, and subject to the court's ruling on what appears to be another objection by the defense, we trust that that ends. Sorry, Your Honor.
Affidavit.
Yes.
You have a copy? Have you filed a copy?
I'm informed that copy has been given.
What I have is one by Florence Muturi. Is that the one?
This is the one.
Oh, okay.
I'm told that I correct it, that the document is currently included. On 18th of October 2023. We are persuaded on behalf of the city that deed is an affidavit that can be relied on and should be relied on in objection to grant of bail to the accused person. Having said so, my learned seniors, Mr. Booth and Mr. Njue, will address you absence of an affidavit on the existence of compelling reasons to persuade this honorable court to find that bail should not and cannot be granted in the circumstances of this case. They will go to the specifics of those compelling reasons from our end. Finally, allow me to address you on the question of public interest. Your Honor, I know and we expect, as we are aware, that the test for the grant of bail is whether or not an accused person shall turn up for trial. But then several decisions of the superior courts of the land are in agreement that one of those criteria probably will be talked about by my colleagues is the seriousness of the offense. And Your Honor, we submit to you that one of the criteria of assessing the seriousness of the offense is the possible impact it will have on the public. Again, without belaboring the point, those several decisions of the superior courts have found that the seriousness of the offense as a ground for denial of bail does not conflict the right to presumption of innocence under Article 50, Sub-Article 2. So that a court that denies bail on the seriousness of the offense, sorry, Your Honor. So that a court that declines to grant bail on the basis of the seriousness of the offense does not in effect violate the presumption of innocence. Off my head, I could refer the court to the case of Republic versus Oleleliman, which has been referred to here, on the balance between the grant of bail and presumption of innocence. I trust that the court would still rely on the copies that were served. Your Honor, if we persuade you that therefore public interest is connected and linked to the seriousness of the offense, and because the list of compelling reasons has been found not to be exhaustive, in addition to the grounds that my colleagues from the ODBP and the Law Society of Kenya will submit before you, we urge you to find that the integrity and or sanctity of legal practice, integrity and sanctity of legal practice in the country as a humongous bearing not only on the national development of the country, but also the national security. As I conclude, we say so because a collapse of the legal practice in Kenya would result into anarchy. And with anarchy, the business environment will collapse. That is how we affect both national security and national development. The importance of the integrity and all sanctity of the legal practice, and comparatively, we look at in the international spectrum where a failure of the peaceable of the possibility to peaceably or pacifically settle disputes because of an eroded legal practice, as in the international level led to what we are currently witnessing. We cannot let that descend into the Kenyan.
On behalf of the victim. Even as much as there was opposition as to whether and I have seen that the affidavit has raised weight issues being moved by paragraph 10 and 11 of that affidavit. When they come to issue of the board bill, to which standard should the state Your Honor, my appreciation is that the standard as it is as regard to prove accused person guilty. Probability. And that is the breach that I beseech when considering the opposition
get some selection before Mr. Kamino, Dr. Kamino makes his interjection. Representations known, so that if there is any response to it, that as my colleagues for the defense may to be of the Victims Protection Act to be had and an opportunity to, as it considers the question of whether to release or not to release, or what kind of conditions to impose, it is necessary